You are in the United States and are married to a U.S. citizen spouse. Your spouse has emotionally abused you and physically intimidated you. You wonder about how to start your Violence Against Women's Act case. We are Francis Law Center and Vawa visa lawyers. We have offices in Chicago, Schaumburg, Naperville, and Madison, and work with clients worldwide. Today, we will explain Violence Against Women's Act visa cases. What does Vawa mean in immigration? In the last 2 decades, Congress has made numerous changes to U.S. immigration laws to offer protections for immigrant victims of domestic violence and crime. The Violence Against Women Act, VAWA, of 1994 included provisions to allow immigrant victims of domestic violence to obtain immigration relief, independent of their abusive spouse or parent through a VAWA self-petition. The Violence Against Women Act of 2005 expanded these protections and included some victims of elder abuse. How does VAWA protect immigrants? Under VAWA, immigrant victims of domestic violence, child abuse, or elder abuse may self-petition for lawful permanent resident status without the cooperation of an abusive spouse, parent, or adult child. Despite its name, the law's protection is not limited to women. If you are a male in an abusive domestic or child-parent relationship, you are also eligible. VAWA allows the victim to confidentially file the self-petition and attain lawful permanent resident status without separating from the abuser. This prevents your abuser from finding out about your pursuit of a VAWA immigrant visa and allows the petitioner to leave the abuser after lawful permanent resident status has been obtained. An approved VAWA self-petition provides work permit, deferred action, and pathway for lawful permanent residency. What is VAWA self-petition? The first step is to self-petition using Form I-360, petition for Amerasian, widow, or special immigrant, and there is no filing fee. Some VAWA petitioners can also submit Form I-485, application to register permanent residence or adjust status, I-765, application for employment authorization, and I-131, application for travel document along with the I-360 petition. In addition, a VAWA petitioner must submit supporting documents to demonstrate the abuser's status as either a U.S. citizen or lawful permanent resident, shared residency between the petitioner and abuser, abusive relationship, etc. How long does a VAWA work permit take? All VAWA cases are currently assigned to the Vermont Service Center. It will take the USCIS about 5 to 6 months to approve an employment authorization document, often known as a work permit. U.S. Social Security cards will be also issued within 30 days of receiving the work permit. With the work permit and valid Social Security card, VAWA petitioners can legally work and obtain driver's license. A VAWA work permit is valid for 2 years, which can be renewed at no additional cost. How do I get a green card through VAWA? There is no limit to the number of VAWA self-petitions that may be filed in any given year. When the individual applies for lawful permanent resident status, however, she is subject to the family preference system and any backlogs that may exist. Thus, spouses, minor children or parent victims of U.S. citizen abusers may apply immediately for green card and receive green cards as an immediate relative. How long does VAWA take to be approved? VAWA processing time is subject to changes. It is currently taking about 30 months for the USCIS to approve VAWA petitions. Then, it may take about additional 12 months for the USCIS to approve adjustment of status applications. In some cases, USCIS may approve your green card applications without scheduling interviews. 3 years after obtaining permanent residency status via VAWA, you will become eligible to apply for U.S. citizenship via N-400 application. Francis Law Center. Make sure to subscribe to our YouTube channel and click the notification bell. Thank you.